Welcome to the Jack Miller Center webinar entitled, Is Court Packing Legitimate? We've got two interesting speakers here today, Joshua Braver, Assistant Professor of Law at the University of Wisconsin Law School, and Professor Thomas Keck, Professor of Political Science at the Maxwell School at Syracuse University. Our moderator is Benjamin Kleinerman, the R.W. Morrison Professor of Political Science at Baylor University, and Jack Miller Center board member, and as he'll explain to you, the editor of a new website supported by the Jack Miller Center called the Constitutionalist. I'll turn it over to you, Ben, if you are ready.
All right. Thank you, Tom. Thank you, Jack.
Let me say one more word. If you have questions before I disappear, if you have questions, enter them in the Q&A box, and at the appropriate moment, I'll be able to relay them to our panelists. Sorry for that interruption. Go ahead, Ben.
Thank you, Tom. Thank you to the Jack Miller Center for helping to put this event together. It's kind of exciting. It would have been even more exciting and quote unquote sexier if the court packing were a real possibility at this point, but it looks like it's not. So we seem not as topical as we were hoping when we thought about this seminar. First, let me just talk a little bit. I'm going to introduce the participants in a minute. I want to talk a little bit about the Constitutionalist, which is the new website that I'm editing that is helping to facilitate this webinar. I think the best idea of what the Constitutionalist is, you'll get by going to the site itself. But generally, I would just say, we think constitutional issues are more than just legal issues, that there is much about norms and political culture as they are about legal issues. And in fact, sort of the current politics illustrates this. It's not clear. It's harder to understand the problems with our current politics merely in terms of the law. The law doesn't provide any easy answers to things like Trump's continuous contestation of the election. The Constitutionalist tries to frame many of these issues in terms of broader questions of norms and political culture. And so we have political scientists or political theorists writing for us mostly, rather than lawyers. And I think so far I think the articles have been good, and we're very appreciative for the Jack Miller Center's support for this endeavor. I think we mirror much of what they try to support. That is, their intent is to support an understanding of the American political culture, and that's sort of what we're trying to also extend or improve. Okay, thank you. So now I'll introduce the two participants of the seminar today. We have Assistant Professor Joshua Braver. He's Assistant Professor at University of Wisconsin at Madison. He's a law professor. He's our sole law professor, both in this webinar and in the Constitutionalist. So we're happy to have you. And then we have Thomas Keck. He's Professor of Political Science at Syracuse University. And again, thank you for joining us, Thomas. I think Joshua is going to start, and so I'll turn it over to him.
Thank you so much for having me here. The question for this panel is court packing legitimate? And in my talk, I'm willing to speak more broadly about it, but in my talk at least, I'm just going to take one piece of that question, which is about the history, which is that many people have claimed, yes, of course court packing is legitimate, because we've done it so many times before. It says apple is American pie, its proponents claim. And here I want to argue that court packing would be nearly, if not completely novel in American history. With one exception, Congress has never passed and the president has never signed a bill to pack the court. Okay, so what is court packing? Court packing is the manipulation of the court size. The court size is set by statute. So the manipulation of the court size in order to change its ideological composition, its rulings. Its distinct danger is that it unleashes a tit-for-tat downward spiral of packing. I pack, you pack, I pack, you pack, ballooning the court size so large that its legitimacy pops. previous changes to the court size were based on a safer and different logic. It might be easy, by the way, if you follow along, and there's a link to my article as well as Thomas's, and in my article there's a chart that might be good to follow along as I say this, and you can see it in the notes and on the Constitutionalist website. So 3 consecutive increases to the Supreme Court size were tied to and regulated by a practice called circuit riding. So in the antebellum era, for every addition of a new circuit court, you needed a new Supreme Court justice. Why? Well, for much of American history, there was not a separate tier of circuit court judges. So no circuit court judges, but there were circuit courts. Each one was composed of 1 district court judge and 1 Supreme Court judge. A Supreme Court judge was assigned to 1 circuit in which he rode, hence the idea of circuit riding. So in the 1800s, America is expanding westward at a rapid clip. These states need new circuit courts to process their claims. And so you ended up with a 1-to-1 correspondence between circuits and Supreme Court justices. For every new circuit, there would have to be a new Supreme Court seat. So if you take a look at the graph in my article, you can see in 1807, we go from 6 justices and 6 circuit courts to 7 because we have the new states of Kentucky, Tennessee, and Ohio. Note, this is a bipartisan measure. Thomas Jefferson's the president. It's Jeffersonians who stand to benefit from the expansion. But 6 of the 7 dissenting votes against adding a Supreme Court justice are members of Jefferson's own party. In 1837, we go from 7 to 9 justices in circuits. This is because of 9 new states. And in 1863, we go from 9 circuits and justices to 10. There are many new states, but this is essential to handle the far western states of California and Oregon. At the time Lincoln is president, he certainly has motive to pack the court. We're in the midst of the Civil War. Lincoln is facing off against the pro-Dred Scott, pro-Southern justices. Lincoln has condemned the court as allies of the slave power, as part of a conspiracy to perpetuate and nationalize slavery. The New York Tribune, Lincoln and the judiciary's correspondents are all calling on him. Let's pack the court, increase it by 2 seats, 4 seats. But Lincoln only adds 1 justice. That was the bare minimum needed to accommodate the far western states of California and Oregon. Pro-Dred Scott justices are still the court's majority. And Lincoln, a Republican, appoints a Democrat to the seat, unprecedented at the time. It's not that partisanship never entered into these calculations, but everyone knew there were rules and limits. Once one person once one person added seats to the court, the other ones could not go ahead and retaliate by adding others. It had to respond to an actual need. And so the dangers we associate with court packing were mitigated and channeled by the performance and administrative motivations of these expansions. Okay, so that's one category of changes, circuit ridings. There's another category which are attempts at court packing. Unlike circuit riding, these changes to the court size are political. It's not about efficiency or administration. What's at stake is the ideological composition of the court. So the first one happens in 1801 and 1802. We have a pair of changes, but this was a failure. John Adams and the Federalists failed to deny the incoming president, Thomas Jefferson, his chance to fill the next vacancy on the Supreme Court. So the setting in 1800, Jefferson and his party win the presidency and majorities in both houses of Congress. The Jeffersonians have the government, or going to have the government. The Federalists are convinced that the Jeffersonians are enemies of the Constitution. So they, as Jefferson bemoans, the Federalists, quote, as Jefferson puts it, retired into the judiciary as a stronghold. During the lame duck, the Federalists reduced the size of the Supreme Court from 6 to 5 seats. When the next vacancy came, Jefferson would be unable to fill it. The Federalists were blocking Jefferson's next Supreme Court appointment. When the Jeffersonians come to power, Congress debates what to do. Furious, the House Speaker Nathaniel McCone expressed his wish to, as he states, add 2 or 3 more justices to the court. McCone wants to pack the court. The Federalist condemnation was fast and furious, but what's more surprising is that no Jeffersonian rose to defend McCone against the Federalist onslaught. In fact, McCone's allies, the Jeffersonians, repeatedly condemned the idea, with one echoing the warning of others, stating, "By increasing the number of judges at every change of administration, the number of your judges are probably to be doubled." But actions speak louder than words. And what the Jeffersonians did, as you can see in the handout, in the chart, is they restored the court back to 6 seats. They described it as a restoration to the old status quo. Jefferson wrote that the repeal sought not to pack the court, but rather, as he states, to restore our judiciary to what it was, while justice and not the Federalists were its object. Adams' packing attempt is not a precedent because it was repealed and repudiated. So that takes us to our last changes that happened under Andrew Johnson. Where Adams was thwarted, the Reconstruction Republicans succeeded. If there is any precedent for court packing, this pair of changes that happens in 1866 and 1869 is it. But if it's court packing, which I think it is, it's of a distinctly less risky sort. So Andrew Johnson and the Republicans are fighting fiercely over the meaning of Reconstruction. In 1866, after Johnson announced his nominee to the Supreme Court, Congress passed a law over Johnson. Actually, Johnson didn't veto it, but they passed a law reducing the Supreme Court's size. Congress is declaring to Johnson, "I will not consider any of your nominees." But the story doesn't end there. After Republicans wrested back the presidency in 1869, the Republican Congress restored the court's size and appointed one of their own to the new seat. In other words, Congress transferred an appointment from Johnson to the next Republican president. This may sound familiar. We have echoes of this in modern times. Nonetheless, this battle didn't degenerate into repeated rounds of packing. Why not? Here, the anti-packing norm was irrelevant because Johnson was a president without a party. Constitutional norms regulate the contestation between the two political parties. This is the point of the Constitutionalist website, after all. They prevent these two long-standing teams from falling into cycles of escalation. So let's take an example. What if there was a bipartisan decision to pack the court? In this case, I'm not worried because both parties are on board. There's not going to be retaliation. It's not partisan in the same way. I'm also not as worried when the attack targets a president who's been deserted by both political parties. Johnson had switched parties so many times, he had alienated so many core constituencies that he had lost the faith of both the Democratic and the Republican Party. As one journalist commented, Mr. Johnson stands absolutely alone. He is his own sole remaining friend. Unhappily, he does not suffice. These attacks on political outsiders are less likely to lead to escalation between insiders. Okay, but just because the elected branches don't often pack the court doesn't mean that they meekly submit to its dictates. There's more than one way to fight the Supreme Court. Instead of packing, the elected branches have narrowly interpreted court decisions, they've circumvented them through other statutes, they've stripped jurisdiction, and the mere threat of court curbing has often been enough. Unlike packing, all of these measures are reversible, perhaps lessening the dangers of a downward spiral. Furthermore, while packing infiltrates and transforms the court, these measures attack the court from the outside, checking the court, causing it to retreat. These measures curb rather than colonize the court. That means they may be more likely than packing to leave the court's legitimacy bruised but not broken. These forms of court curbing, not packing, are the hallowed American tradition. Traditions do not bind. Nothing about past American constitutional history commands that we repeat it. An unprecedented tactic may be a good one. But there are plenty of other ways to attack the court. And it's worth thinking about whether these surgical, more precise, less explosive measures are sufficient to achieve progressive ends. Thank you.
Thank you, Josh. And now to Professor Keck. Thank you.
Great. Thanks so much, Benjamin. And thanks to everyone for joining us. So again, I'm Tom Keck from Syracuse University's Maxwell School, and I appreciate the opportunity to engage in this important conversation. So calls for altering the size and structure of the Supreme Court are a recurring feature of its history. This is clear even from Professor Braver's presentation. And as he reminds us, court expansion and reduction are only part of a broader menu of court curbing actions that Congress and the president have regularly considered and occasionally enacted. These calls have repeatedly been provoked by actions taken by the justices themselves and by the political coalitions with which the justices are allied. So these provocations come in a variety of forms. I'm going to mention three, and I'm going to give you a brief historical example of each one. And some of these examples overlap with the examples that Professor Braver described. So in 1800, in 1801, after John Adams and his Federalist Party lost the election, during the lame duck period, right? So during the very period that we're in right now, right? Following a presidential election, but before the new president and the new members of Congress are seated, John Adams and his Federalist allies in Congress engaged in a systematic and blatant effort to install their partisan supporters in life tenured judgeships, including the famous, quote, midnight judges whose commissions were being delivered right up until the very last moments of Adams' tenure. In response, the incoming Jeffersonians engaged in court packing once they took office. They simultaneously expanded the size of the Supreme Court from 5 back to 6, and also reduced the size of the lower courts, and thereby fired 16 life-tenured federal judges because they were trying to respond to what they saw as the illegitimate court packing of their predecessors, right? So John Adams and his allies pushed through some midnight judges in an illegitimate power grab, and then the Jeffersonians come in and they alter the size and structure of the federal courts in an effort to respond. That's one way in which calls to alter the size and structure of the court get provoked. A second way brings us to the Civil War era examples. So before, during, and after the Civil War, the court repeatedly threatened to engage in what comparative court scholars call abusive judicial review, right? Using judicial power to undermine core features of electoral democracy. Right, so prior to the war, there's the Dred Scott decision, which held unconstitutional the key domestic policy commitment of Lincoln's Republican Party. During the war, there are multiple actions by Chief Justice Taney seeking to undermine the Union war effort by attempting to overturn military orders issued by the commander-in-chief during war repeatedly. But what I'm thinking most about are some actions that Professor Braver alluded to, taken by President Johnson after the war. So after President Lincoln's assassination, President Johnson goes to extraordinary lengths to undermine the Republican Congress's effort to build a multiracial democracy in the US South. And Congress is afraid that the court is going to side with President Johnson and participate in his efforts to undermine Congress's efforts to establish a multiracial democracy in the US South. Fearing those actions by a court and with a vacancy on the table and with a nomination from President Johnson for that vacancy just recently announced, Congress reduces the size of the Supreme Court from 10 to 7, preventing President Johnson from capturing the court and using it to undermine Congress's effort to build a multiracial democracy. Once Ulysses Grant, the Union war hero, once Ulysses Grant succeeds Johnson as president, Congress adds 2 seats back to the court, increasing it from 7 to 9, right? So again, you see here congressional actions altering the size and structure of the court multiple times, in this case, in an effort to respond to a fear that the court is going to undermine Congress's effort to build a multiracial democracy. Third example, this one we haven't talked about yet, and any webinar focused on court packing, I know we have to talk a little bit about FDR and the New Deal. So let's take this example from the 1930s. When FDR was elected in 1932, in the midst of the worst economic crisis in US history, the court during his first term regularly and repeatedly struck down New Deal statutes by which FDR and his Democratic allies were seeking to respond to the Great Depression. Right? Unemployment was at 25%, banks were failing nationwide, and there was no federal deposit insurance at the time. Labor violence was increasing, and the court repeatedly, over and over again, held that Congress and also state legislatures lacked any authority to regulate wages, hours, working conditions, and the like. When FDR ran for re-election in 1936, there were pending lawsuits against the Wagner Act, the National Labor Relations Act, landmark New Deal labor law, and also against the Social Security Act, right, establishing unemployment insurance and retirement security for the first time. There were pending challenges against both of those laws, and those challenges were widely expected to succeed. The court was widely expected to strike those laws down as well. FDR gets reelected in a landslide, and he then famously proposes increasing the court size from 9 to 15. That court packing plan was not enacted in Congress, but principally because the court itself backed down. And shortly after FDR's announcement of the plan, the court issued surprising decisions upholding the Wagner and Social Security Acts. And if the court had not backed down, it is likely that some version of FDR's court packing plan would have been enacted. Now, obviously, that's a really quick run through of three big and complex historical examples, and I'm sure we can discuss them more in Q&A. But what I think that the point I just want to emphasize to get us started is what is so remarkable about these three historical examples is they all have parallels today, right? In other words, the Roberts Court and the political coalition with which it is allied have been provoking court reform in multiple ways, right, that it has been provoked in the past. Indeed, almost every way that it has been provoked in the past is relevant right now, right? So again, three quick examples to tie the current situation to those three historical examples, right? So one clear parallel is the Midnight Judges, right? Like Adams and the Federalists in 1800, Trump and his Republican Party have bent and broken a number of existing norms in an effort to install their supporters in life tenured judgeships on their way out of power, including historically abbreviated rushed confirmation process for Amy Coney Barrett to the Supreme Court immediately before the election in which Trump himself was voted out of power. So that's a clear parallel, right, with the outgoing party attempting to install its supporters and altering existing norms and procedures to install its supporters in life tenured judicial seats on their way out of power. The second example, I would argue, is well underway, right? Like Andrew Johnson and the Democrats in the 1860s, today's Republican Party has been undermining the country's commitment to multiracial democracy, and the Roberts Court has been helping them. This is a long story, which I hope we get the chance to discuss a little more. If you look at my essay on the Constitutionalist, you'll see some examples there. The third parallel is more speculative, but appears to me likely to unfold, right? So this one has not actually happened yet. This is the parallel with FDR and the New Deal. This one hasn't happened yet because Joe Biden has not yet been sworn in. But if the following scenario unfolds, then we will have this third parallel as well, right? If the Biden administration is able to enact any significant new domestic policy, right, either via legislation enacted in a closely divided Congress, right, if Democrats win the 2 Georgia Senate races, or via unilateral executive action, where the Biden transition team has been signaling a number of areas where they think they can make important policy changes unilaterally. Via either of those procedures, if the Biden administration enacts any significant new domestic policy, the Roberts Court is likely to veto much of it, right? We've seen an early sign of this with the court's recent decision in joining Governor Cuomo's COVID-19 lockdown orders as applied to religious institutions. And we are likely to see similar judicial responses to new Democratic policies on healthcare, climate change, gun violence, voting rights, and more. Again, lots of different stories there, lots of complicated examples, happy to discuss them further. But the upshot is that come January 2021, President Biden will find himself facing a Supreme Court that has been illegitimately packed by the opposition party on its way out of power, that stands opposed to majoritarian multiracial democracy, and that is committed to a constitutional vision under which much of the platform on which Biden was elected is constitutionally suspect. If history is any guide, court reform will remain on the table until President Biden's political coalition collapses or Chief Justice Roberts steers a non-obstructionist path. If neither of those stories unfolds, then court reform is virtually inevitable. And so I'll stop there and look forward to further conversation.
Okay, thank you both for that. We do have questions in the queue, but I'm going to ask a couple of questions. The first is, I'm asking as much because I'm interested in it as because it's directly relevant. It's actually why I'm interested in the question of court packing. That is, I mean, obviously the Constitution says nothing about the number of justices, which potentially makes it a constitutionally open question. But, you know, we've had also this phenomenon of constitutional construction. So I think one of you talked about the Chase impeachment, which strikes me as the most clear example. Keith Whittington talks about this in his book of constitutional construction. The question prior to the Chase impeachment was whether impeachment could be used for quasi-political reasons. And a popular president tried to use impeachment for quasi-political reasons and is rejected by not only the opposing party, but even by some members of his own party. And I think a new construction of the Constitution, that is that impeachment of justices can't be used politically, was formed. And so I guess my question is, what's the status of that kind of constitutional construction with court packing? And what do you think about constitutional construction more generally?
So I'm happy to jump in on this one. So I'm actually a big fan of Whittington's account of the Chase impeachment. And it always gets cited that Whittington argues that two constructions were drawn from the Chase impeachment, and it often gets cited for only one of them, which is the one you just mentioned. What Whittington argues is that political actors at the time drew two lessons from it. One is that a newly elected administration should not use impeachment simply to remove judges that had been appointed by the prior regime. But the other is that judges should not abuse judicial power for partisan ends, which Chase himself had blatantly been doing, right? Giving partisan harangues from the bench in open court during an election. And so Chase blatantly abused judicial power, and the Jeffersonians tried to impeach him for it. They fell just short of convicting and removing him from office. But the lesson from that was to chasten uses of the impeachment power, but also to chasten partisan uses of the judicial power, which is a fair constitutional settlement, right? That sort of de-escalates the stakes there. And so the lesson, I think, for court packing, right, is that the impact of court packing on the health of our Constitution is going to be very context dependent. Nobody argues that every party after every election should change the size of the Supreme Court, right? But there are circumstances in which the powers of the courts are being abused in ways that harm constitutional and democratic health, such that an unusual remedy is called for, right? In the hopes that then we can reach a new equilibrium, right? Where there's some de-escalation and we don't fall into the tit for tat constant cycle of everybody packing the court over and over again that Professor Braver alluded to.
Yeah, I'll just add briefly. Norms are important. And what Keith Whittington is pointing to is a norm about impeachment, and we all know we have a norm, or at least had a norm, against court packing, but norms are also meant to be broken, right? When we're trying to change the constitutional system, when we're trying to inaugurate what in political science is called a new regime, then political actors break norms. When FDR accepted the nomination from the Democratic Party, at the beginning of his speech, he said, "We will be the party that will break all foolish traditions," right? And he meant norms. So the complicated question is, when and how is it legitimate to break norms? To what extent? Which norms should you break? So I am not particularly concerned, unlike Keith Whittington, perhaps, about the norm about when you can impeach judges. I just don't think that's a big concern. And I agree with Thomas Keck that when judges are acting abusively or egregiously, or even when we need a new regime, that you have to take the offense. What Thomas and I just disagree about is what weapons you should use in that offense, which norms in particular you should push or pull upon. And I think court packing is a really dangerous escalation that has not been used in our history, because even though we've changed regimes, right, even though we have something like Reconstruction, right, or the New Deal, there's a reason we use the word Reconstruction rather than revolution, right? This is not like the changes in Eastern Europe, right, or the overthrow of the Soviet Union, where there's an idea where we really have to create a whole new court, right? We are in this weird land in these changes, one in which we're in today that's somewhere between reform and revolution, which makes it very difficult to figure out just how badly and how severely do you want to break and violate constitutional norms.
Yeah, I mean, that's an interesting argument. I mean, the only lightly thing I'd say is one person's norm that needs to be broken is another that needs to be absolute, because the politics aren't sufficient to break it. Nonetheless, I think totally lost my train of thought. I'll turn to the next. I mean, this was what I was going to ask. To some degree, didn't the New Deal, the rejection of FDR's court packing plan, settle the issue? Because that's always, it was such a clear constitutional construction when the most popular president perhaps we've ever had tries to pack the court and the people still say no. It strikes me as a pretty strong rejection of the very concept of court packing, at least on the part of the people. I'm tempted to say it's one of the, there are these kinds of, what are the law professors, new constitutional amendments that don't quite actually become amendments, instead of Bruce Ackerman's new concept. Court packing strikes me as having become one of those amendments, right? I mean,
so I think that's right as far as the conventional wisdom goes, right? So one thing I said, Professor Braver and I have been having this conversation in writing back and forth over the past couple of months about court packing and when and whether it might be legitimate. And he wants to argue that there's this existing story about court packing as legitimate, and he's going to sort of burst that myth. And in fact, I think that framing is always struck me as somewhat unusual, because the existing conventional wisdom has always been court packing is completely illegitimate, right? Since FDR, the dominant conventional wisdom has been that court packing is illegitimate. In the past year or two, a handful of pundits and scholars have tried to chip away at that conventional wisdom, both by sort of recovering earlier historical episodes that were not as well remembered as the FDR story, but also by sort of reframing the FDR story. And one thing I'll say about this is a long, complicated story, but so again, FDR's court packing plan is defeated in large part because the court backs down. Second, the sort of conventional wisdom that treats it as a classic example of executive overreach, power-hungry FDR tried to take control of all the institutions, and members of Congress of both parties stood up for our constitutional norms and institutions and pushed back against him. That's the conventional story. If you look under the hood a little bit, it's a lot more complicated than that, right? There's two main groups of Democrats in Congress who opposed the court-packing plan. Neither of them had enough votes by themselves to block it. And one of those groups of Democrats is white Southern segregationists who were against court-packing because they saw correctly that FDR hoped to use the federal judiciary to promote civil rights for African Americans, right? And so the Democratic norm erosion is present on both sides there, right? The NAACP supported court-packing. The Ku Klux Klan opposed it, right? I mean, it's right. Kevin McMahon's account, which I highly recommend, of FDR's impact on the court, quotes extensively from Carter Glass, senator from Virginia, Carter Glass, white segregationist senator from Virginia, his radio address opposing court-packing, and it's like the worst of like Southern lost cause revisionism, right? And that's not the only thing that was going on, but that was a big part of the opposition to court-packing. And so there's efforts to, the conventional wisdom is FDR's failed effort to pack the court sunk that tool forever. But in recent years, given the stakes that we're faced in our current political moment, some of us have been trying to sort of dig back into the history and think about these previous stories in a different way.
Yeah, let me respond to a few points. You know, the conventional story, we're both like calling each other the conventionalist, but the conventional story, I think, is it's called the switch in time that saved 9, right? This is the famous phrase, right? And the famous phrase suggests, as Thomas is arguing, that the court-packing battle was lost, but the war won, right? It was only because FDR was willing to be a little crazy, right? To play chicken with the court, that the court backed down. And I didn't have time to go into my remarks, but I think that's basically wrong. This famous Supreme Court decision in which the Supreme Court did the switch in times called West Coast Hotel B Parish, and the vote to take cert on that was before the 1936 election, right? So before court-packing had been announced, before Roosevelt goes. And then there's no reason to take cert unless you want to reverse, right? This is done by Roberts, right? There was a Roberts then, there's a Roberts now, ha ha ha, cool historical parallel. And then the vote to reverse the decision is 3 months before FDR announces his court-packing plan. So why did the reversal effectively happen before Roosevelt announces the court-packing plan, before Roosevelt is reelected? Well, the reason why is because there were lots of other threats against the Supreme Court that were happening all over the place by Congress, right? By people who would later oppose, by the way, the court-packing plan, but wanted to strip the court of jurisdiction, wanted it to have a 2/3 requirement, wanted it to have lots of other ways of pushing back up against the court. So it's not only that FDR's plan failed, right? It's that it was unnecessary in the first place. That if he had followed along in the much longer tradition of how you push back up against the court, he might very well have succeeded without blasting apart his coalition. Now, the other part that's brought up is Thomas, and I'm somewhat sympathetic to this, wants to say, you know, if you're, this is the way we do history and constitutional law is like, if you are against court-packing, your company is Southern segregationists. And I know the book he's talking about by Kevin McMahon, and it's an important and interesting book, but Kevin is pushing up against the conventional wisdom, and there are lots of scholars who disagree with them. I don't think that it's particularly clear that Roosevelt in court-packing was catering to the NAACP, right? I just don't think the historical evidence is particularly clear on that, and it's something that I think bears further study and reflection. I mean, it's certainly true that moderate Southerners opposed it, but the coalition against it was not just, as Kevin suggests, moderate Southerners, the four central people, and a few progressives, Democrats. It was a much wider coalition that does not follow along traditional Southern lines.
Yeah, one of the things, just for whatever it's worth, that always, it's never been clear to me that FDR really wanted to pack the court. He wanted to make it a threat to pack the court, such that the account by which he lost the battle, it's not even clear how much he wanted to fight the battle. You know, anyway, I wrote on this a long time ago, so shouldn't speak as an expert now.
The one other thing I'll just add about FDR, just while we're at it, sorry, to jump in, and I know there are questions, is, it's not only Southerners who oppose it, it's the general public, which is a really striking thing. And I don't want to extrapolate too far from how the public views court-packing in 1936 to how it would view it today. Well, there's a very different public. But FDR wins this massive election in 1936, every state but Maine and Vermont. The court is, unlike today, very unpopular in the general public, who almost all agree that its decisions are wrong, that a constitutional amendment should be passed to overturn their decisions. Yet that same public who hates the court, who loves Roosevelt, when you look at the public opinion polls, and there's been a lot of good work done on this, they opposed court packing, right? They were the supporters of a blog like the Constitutionalist. They really thought that the norm against court packing or the idea of court packing was illegitimate, even in 1936. And I think that's a striking thing to bear in mind today.
That brings me, I wonder, to what extent has, it's almost, Professor Braver, you've said there are other ways, more scalpel. There's other ways of affecting court decisions other than court packing. And yet Congress doesn't think at all about those ways. So it strikes me that the attraction or the reason why court packing has come to the public discourse so much is precisely because Congress isn't using those other powers. In a way, it's either throw the grenade or do nothing. So the jurisdiction stripping, you hear almost nothing about that as a possibility, whereas it really is a constitutional possibility. I think
So can I jump in on that point? So the Republican effort to capture the federal courts has been a generation-long effort, right? Which I was born in 1970, and there has never been a Democratic majority on the Supreme Court in my lifetime. But the usual story is that up until the Trump administration, right, that effort had never fully succeeded, right? So there's like a long-running effort to capture the courts, but we alternate Democratic and Republican presidents. Clinton and Obama both appoint a lot of judges, right? And so the Republicans never quite capture that holy grail, right? So only when Trump is elected in 2016 does the prospect of a firm Republican capture of the Supreme Court become a reality, right? A firm like conservative ideological Republican capture of the Supreme Court become a reality. And so prior to the Trump era, there's no discussion whatsoever in Democratic policy circles of court curbing, right? It's just not necessary, right? During the Trump era, it starts to seem necessary to some folks, but there's no prospects of any form of court packing. None of the items on Professor Braver's list are possible when Trump is president, right? So the fact is that we don't know yet what variety of court curbing legislation Democrats might consider if and when they'll be in a position to enact some of it. Everything we've been talking about in the past few months has been looking ahead to a potential Biden administration with a potential Democratic Congress. And so I do think we will see a variety of proposals floated. Democrats' majorities in both houses are going to be too narrow at best to enact any version of this, probably. But I think there'll be some policy experimentation. But one of the reasons why pundits and scholars, still I would say a small minority of pundits and scholars, have turned to court packing is out of fear that most of the other items on Professor Braver's list are more readily subject to judicial invalidation than court expansion is, right? So the very court that you are trying to reform is in a position to invalidate any court reform legislation that you enact, right? So the kind of jurisdiction stripping that's used during Reconstruction, I would bet money on the fact that the current court would strike those laws down now. I think it would be harder for the current court to strike down a law altering the court size. So the court packing, just as FDR considered a whole bunch of alternatives for how to respond to the court and settled on court expansion as the most workable. So I think Democrats, if they're in a position to do it, and if the court becomes quite obstructionist, Democrats will consider a variety of alternatives, but one of the things going for court expansion is that it can be enacted by simple majority votes, and given the precedent for it and given the constitutional text, it's harder to picture even today's Supreme Court striking it down.
Yeah, I mean, I just a couple things. So responding to Thomas, then responding to you. I mean, I agree that there's more precedent about jurisdiction stripping than there is about court packing. But the precedent is not, it's confusing, it's cryptic, and it's not like clearly against, or even close to clearly against jurisdiction stripping. And I have to say, I don't think it would be, you know, for the one hand, for court packers, of which I'm very sympathetic, to argue that this court is so nuts that it will strike down anything the Democrats do. But on the other hand, if court packing comes, they're just going to roll over and die about it. I think there's some tension in that argument. And I think it would not be very hard for a Supreme Court to make an argument that court packing is unconstitutional. They would say these other changes were mostly administrative, so that you can change the court when it's only for administrative reasons. And here we're going to strike it down. If the court can come up with Bush v. Gore, I don't think it's going to be that hard for it to figure out a reason to strike down court packing.
Sure, I agree.
The other question you bring up is,
but then that's also true of all of the other items on your list, right?
That's true. And so then the real question is whether you're going to summon up enough political will to threaten the court into submission, not about whether one is particularly less constitutional than the other. We've already seen conservatives come up with arguments that
sure, but the one thing I would say about it is that there are currently existing well-developed conservative lines of doctrine which threaten much of the Biden administration's domestic policy agenda, just as there were currently existing well-developed lines of doctrine that threaten Lincoln's domestic policy agenda, right? So under current doctrine or like reasonable small extensions of it, lots of Biden's proposed legislation on health, climate, guns, and voting rights is constitutionally dubious in the current court's mind, right? So those don't even take very much of a leap. It takes a bigger leap for the court to strike down a straightforward court expansion bill. If it was something like Representative Khanna's bill that he introduced a month or so ago, which tries to combine court expansion with term limits in a complicated way, I for sure think the current court would strike that down. But if it's straightforward court expansion, which there are not the votes to enact, right? Nobody thinks this is going to be enacted anytime soon. But I think the scenario to sort of play out in one's mind is the 1930s scenario. I don't know if this is going to happen. But what if the court steers a maximally obstructionist course to the Biden administration's domestic policy agenda, right? Then what is the reasonable response from the Biden administration? That's the scenario I think people should be focused on.
Okay, I think we have some questions from the audience. So I'm going to let Professor Cleveland introduce those. Thank you. Tom, introduce them.
I was going to pitch one to you that's related to what you were just saying from Rory Womack. He says FDR's court packing plan was to ask for a statute that would allow the president to appoint one additional judge for every justice who refused to retire at age 70 up to 6. Could he have gotten away with it if he took a more populist approach and simply said, court packing is what we need to get the New Deal done? I imagine that the Democrats today would be much more likely to take this route than couch it in an argument of cogency like FDR tried to do.
Yeah, so that's a really interesting point, and it's a common line that FDR screwed the pooch by wrapping it in this performance move. I'm not so sure though that that Democrats would be more likely today than FDR was to openly admit their intentions. And I'm not sure that it would be a good move. I mean, we've just had an election where it seems like the average voter in many ways, at least under the current system of the Senate and the Electoral College, is remarkably more conservative than we had imagined, that there's a kind of status quo bias. And I think probably the failure of FDR was that he came up with such a stupid explanation of why the court needed to be expanded. And we might want to think about explanations where we could expand the court if you want to do court packing, and it would actually be a good thing. So Jack Balkin has a proposal that, and it was a bill recently introduced, Thomas Keck mentioned this, where the president would be able to appoint a justice in his first year and his third year, and they would serve for 18-year terms. So is there a way to make this so that it has a kind of partisan bent? You know, Jack Balkin doesn't want to introduce this for like 10 years, so it's behind a veil of ignorance. The bill that's been introduced means that this won't affect the tenure of current justices, right? So the idea is 18-year terms, right? Every time a new person is appointed in the first year or the third year, the most senior justice retires. Well, what if you introduced a bill where it did affect the current justices? Where in fact, when President Biden, let's say it's President Elizabeth Warren 4 years from now, right? In her first year, she appoints a new justice. Well, that means Clarence Thomas, I think he's the most senior justice, would have to go. Next, it would be Breyer, right? After that, Alito, right? That's a kind of way of thinking about mixing reform and partisanship. And this is, I think, kind of the strategy behind a lot of what Democrats are doing. It's what Eric Holder called partisan good government, right? We want Puerto Rico and Washington, D.C. to be a state because we think it's just and it's fair. And it also gives Democrats a partisan advantage. We want independent districting commissions because gerrymandering is unfair, but we also think there's a partisan advantage to Democrats. And I think this kind of, I don't know how well I explained it, but this 18-year term that bumps off conservative justices that are on the court, as well as some liberal ones, would be a good way for Democrats to go.
Are there more questions, Tom? Should I ask the next one?
I can submit another.
Okay.
Do you want to throw a couple questions on the table, and then we can?
Why don't I read a couple and then you can address them? Here's a broad one from an anonymous attendee. I'm a little suspicious of this concern regarding, quote, norms. If something can be identified as a norm rather than just the way things are done, hasn't the ship already sailed? Don't we have a written constitution partly so that we have at least a baseline for rules of governance, not solely rely upon norms? So that's one. Let me pick another. Here's a question from Jack Capri. I wonder if a separation of powers argument has any legs against court packing, I think. It would be something like this. Congress has constitutional authority to organize a Supreme Court. However, organizing it for political or partisan ends violates the spirit of the Constitution's separation of powers by turning the court into an arm of the legislature, legislating by other means/branches. The Supreme Court itself may not be able to enforce the norm of separation of powers, but Congress may have a constitutional duty to protect its role. Well, yeah, why don't you address those two, and then maybe we can even get to another.
So I can jump in briefly with a kind of at least half response to both of them, right? So on the norms issue is a complicated one. It's one that scholars are very much focused on at the moment, because in the United States and a variety of other democratic countries in recent years, we've seen what political scientists call democratic erosion, right? A decline in the health of democratic governments, right? And so these are functioning democracies, not always with as long of a history of democratic government as we have in the United States, but functioning democracies which have competitive elections and have a free and independent media and have independent courts, and an authoritarian-minded leader comes to power. And it turns out that the built-in legal rules written in the Constitution are not sufficient by themselves to constrain an authoritarian-minded leader from undermining the constitutional and democratic character of the government, right? And so many scholars have argued that in addition to the written legal rules, there's a variety of democratic norms that are also important, right? So the norm of a peaceful transition of power is a very important feature of democratic government. And if a current office holder just decides he doesn't believe in that norm and says he's not going to abide by it, right? That's a sign of some significant democratic erosion. On the separation of powers argument against court packing, I think it's a really good point. And I think conservative litigators and potentially conservative judges would be very sympathetic to that argument if a democratic court packing bill were to be enacted anytime in the foreseeable future. I think there are responses that can be made to that argument, including that the framers intentionally left the size of the court up to congressional control. But for sure, I think conservative lawyers and judges would be sympathetic to that argument. And depending what form the court expansion bill took, and depending on what the political context was at the time, the court might well strike it down, as Professor Braver suggested a few minutes ago. So yeah, there's no, FDR considered a wide range of potential solutions, and he thought the court expansion bill he came up with was far from the most extreme of the options on the table, which included abolishing the court's power of judicial review. He said, I'm not taking away any of their powers. I just want some more modern-minded justices there who know how the modern economy works. And so yeah, there's a variety of policy responses to a court that is undermining important commitments of our constitutional democracy and the American people. And none of them are perfect, and all of them have upsides and downsides.
Yeah, I agree with a lot of what Thomas just said. Just on the point of this argument about it being a violation of the separation of powers, 2 points. I mean, I think it is a good and a really important argument, and it has precedent. You're not the first person to argue it. You're in line with a great line of people during the New Deal who made this argument. Famously, the Senate released a report, the Judiciary Committee, that had very wide circulation, and it made the same argument, partly based on history, that it was a violation of the separation of powers. They didn't say it was unconstitutional. Instead, they said it was, quote, anti-constitutional, right? Which is this idea of norms, right? And you said in your question, like, you don't really expect the judiciary to enforce this. And the interesting question, I think, is, what likelihood is there that the judiciary would enforce this, or even broader than this current, kind of sexy or unsexy moment? When should a judiciary constitutionalize these kinds of norms? And we already do see a movement among some conservatives. There's this article in Newsweek that got a lot of play to try and judicialize, to try and make it a judicially enforceable norm against court packing. This runs straight up against, the big problem with this to me is that, the court size was manipulated during Reconstruction, 1866 and 1869. Both Thomas and I agree on that. I see it as being a really exceptional moment where the dangers were mitigated by the fact that Johnson was not really supported by either political party. Thomas is probably skeptical about that, and we can talk about it. But at the very least, for the purposes of not concerns about tit for tat, but the concerns from an originalist court about whether there's any precedent for court packing, it seems to run up against that example pretty squarely. But we try and distinguish Reconstruction examples because it was such a wacky time sometimes. I think that's a mistake in this case. But.
Are we out of time?
We are. We could take another question if you're willing to stick around, but yeah, we're just about out of time.
I'm going to leave, but you guys keep talking.
Yeah, I have.
Well, we probably, it's unfortunate we can't get to all the questions, but I would say it was an excellent discussion, and I learned a lot from everyone. So check out the Constitutionalist.org.
Did you want to do one more question? Sorry.
Oh, okay, you're willing to
I was joking. I was being unfunny.
Why don't we do one more for the heck of it? Let me find another. How about this one? The panelists accept the idea of regime change without constitutional amendment. When is this type of regime change legitimate? And what are the brakes on regime change that would be considered illegitimate by the panelists? So another norms question in a way.
It's a big question. I'll jump in briefly. I'm sure Josh has a lot to say about it too. So there's a lot of literature in constitutional development on this. One of the works that I've been most influenced by is Bruce Ackerman's line of work. And so it is clearly the case, in my view, is that it is clearly the case as an empirical historical matter that we have sometimes fundamentally altered our constitutional order in the absence of formal constitutional amendments. And the clearest example of that is the New Deal era, where whatever you think of his strategy, FDR succeeded in remaking the court and the Constitution, right? A court that was regularly striking down minimum wage laws in 1936 was upholding minimum wage laws unanimously 5 years later, unanimously, right? And so it was a fundamental change to constitutional understandings about the scope of federal legislative power, federal executive power, and a variety of other things. And no formal constitutional amendments were enacted. Whether those changes are legitimate or not is a harder question. And so Ackerman argues that they are in FDR's case, and he has a complicated argument about the American people's repeated expressions of their endorsement for FDR's agenda. He did get elected 4 times, right, with large Democratic majorities in both houses of Congress. So, the short version of that argument is that if a president is publicly defending a new constitutional vision, and not just once, but repeatedly gets the public's endorsement for that constitutional vision, that should be considered a legitimate constitutional change. But Ackerman himself argues that is a suboptimal way to do it. And it would be better if we had some more direct way for the public to weigh in on proposed constitutional changes, because our existing Article 5 amendment process, designed in the 18th century in a very different political context, it is pretty outmoded.
Yeah, I agree with all of that. I'm a student of Bruce's. I guess the only thing I'd add is really just how broad some of these, not in Reconstruction. Reconstruction is different because you have a civil war, but it's interesting the attempts to make concessions to the losers in these moments of constitutional change. So the easiest example to understand is the Bill of Rights, right? And this is contested, but there's, the Anti-Federalists lose, right? The Constitution is ratified, but one way to soften the blow, in some sense, is to give them this Bill of Rights. And so it's interesting to think about in moments of constitutional change in America, how we've tried to include the losers, make sure that they feel that they can fight another day, in contrast to other revolutions where the idea is we want to exclude the losers as much as possible so that we don't have to moderate the change, so that we can make the change as radical as possible. This is the French Revolution, this is the Russian Revolution. And when the losers can't accept things, then we have civil war. We have the white Russians rebelling. In the French Revolution, we have the Vendée. And so there's something in America where we manage to, I think, somehow get the losers to accept the results by partly giving them a few important concessions, and by making sure the agreement is particularly broad rather than just narrowly majoritarian. That's worth considering. But yeah.
I think that was our last question. I appreciate you all for coming, and I thank you. Thank you to the Jack Miller Center for putting this event on. It was a fascinating discussion. Thank you.